Okay, can we all see the screen?
Yes.
Fabulous. Okay, thank you very much for the introduction. I'm Jill Coote. I'll be taking you through this session today, and what we're going to be looking is at business documentation, contracts, policies and handbooks, and what is the best things to have in your business to enable to run your business effectively, compliantly, and so there's also clear understanding between yourself and your employees, your workers, of what the rules of your business are. So we work in partnership with IIRSM, and just to let you know, anything I go through today, unless I state otherwise, is based on GB employment legislation. So just an introduction to Kroner. I appreciate you have access to us through the association, but we are the longest running employment law and health and safety company in the UK. We have been in existence for over 80 years. We look after a high number of trade and member associations, of course, of which you are also members. And we look after many clients, from low risk to high risk, small business to high business, large business, all sizes in between. Because when you're managing staff within a business and running a business effectively, getting it right first time is key. The documentation you have, the decisions you make, the discussions you have, making sure that you have those things in place are so important. Now, as a bespoke client, you have access to obviously bespoke contracts, policies and procedures. You have the advice line, which is very much HR case tracked as well. We also indemnify you with our advice, and you have protection in the employment tribunal. As you can see, our employment tribunal success is 80%. Now, some people say that's a bit low considering what we do, but often we come in when you already have the issue. So then it's due diligence and damage limitation, which is also very important for your business. And as you can see, we've taken many advice line calls. We took 275,366 advice line calls in 2021 from our bespoke clients. And no question is a silly question. Even if you're a HR manager, we're your best friend. We're not going to put you out of a job because, as I mentioned, the movement you make in your business where your employees are worker concerned, it's very important you get it right first time. And the reason for that is employees have 78 statutory rights from the very first day they join you. And they continue to grow over 2 years. Now, as an employer, you have no statutory rights. So it's really important you embed how you want people to behave within your business. And that's what we're going to be looking at during this webinar. Now, as a member through the association membership, you have access to free advice and support. And through your association membership, you also receive discount on Kroner services. And if you are interested in that or having a more bespoke processes in your business, then you can contact Chloe Mann directly for more information. And as you can see on the screen, the email address is chloe.mann@kroner.co.uk. And the benefits of joining Kroner yourself are the employment law services, where you have the bespoke support, the employment service insurance covering the defence of any future employment tribunals, health and safety support, 24-hour case management service, and employee assistance programme, the EAP, which needs to be underpinned with the well-being in your business. You're not just responsible for employing people, you're also responsible for the health and safety and their well-being at all times through the Equality Act changes in 2010. So what we're going to look at in line with what I've already spoken about is, first of all, what to include in the contract. Then the importance of clear contractual terms and policies. Then we're going to look at the policies that must be used and those that are a really good idea to have in place. And if you want to change a policy, the processes you need to go through and what problems it could cause if it's not done properly. And the benefits of regularly updating company documents. So let's have a look at this. So the question is, have you taken on an employee or a worker since the 6th of April 2020? Because from that date under the Good Work Plan, the latest you can give somebody a contract of employment or a written statement of main terms is day one. So if you're not sure what this means for you, this really came in when we were knee deep in the pandemic, so I appreciate it did get overlooked quite a lot. So first of all, if you've taken on employees since that date, are your contracts fit for purpose? And secondly, if you haven't got contracts in place from day one, have a word with us because we want to make sure you are compliant and doesn't leave your business exposed. But that's the latest you need to issue a contract moving forward. And the contract of employment is exactly that, it's a contract on both sides. So written correctly, it's essential your employees really understand what you expect from them in their role. But also, as I say, a contract is both sides, what they can expect from you, what you will do for them. And that's why contracts of employment exist. And as already mentioned, providing an employment contract is a legal requirement, but believe it or not necessarily required in writing. This is a verbal employment contract, but this is very vague for both the employer and the employee once there becomes an issue that you need clarity on. So, trying to say in employment tribunal, we've got a verbal employment contract, it would really be very, very difficult for you to communicate that in an ambiguous manner. Now, as business owners, managing your business is time consuming enough. And there's lots of different contracts of employment laws you need to follow. And if things aren't vetted effectively, you can face unfair dismissal claims on the termination of an employment contract if they're poorly drafted, or you commit a breach of the employment contract. And I see lots of claims for breach of contract because the contract works both ways for the employer and the employee or worker. There's three elements to an employment contract. So you've got the statutory parts that need to be embedded there through the Good Work Plan, and we'll look at those in a moment. The explicit part, and that means the relationship. And then the implied term. The implied term is what really happens in that term of employment. So what do you need to include in a statement of main terms or an employment contract? So first of all, the names, who the employee is, who the employer is, the department head, etc. The date the employment starts, what the job title and a brief description of what that will be. The workplace details, what the working hours are. And don't forget, you've got the working time regulations you must comply with over that. What the probationary period with the option to extend, what the salary deductions will be. Are there any employee expenses? Do they get travel expenses, business expenses? What about their holiday entitlement? The sickness absence processes, so sick pay entitlement, what the policy is for sickness absence. Termination, what notice is required, what notice needs to be given, what notice period there is. What your grievance and disciplinary procedures are. Your retirement processes now, obviously there's no default retirement age due to that being removed of age discrimination, but is there a procedure for voluntary retirement? Do you have a severability clause? But please be mindful, each clause is independent. So if one does not apply, others still do apply. So, do take advice on that. Are there any prior agreements? So a statement that all prior agreements are invalid upon signing the contract. And the jurisdiction of which law applies. Is it English, Welsh, Scottish law? And a few examples there for you. Contracts are not set in stone. And you can make changes or variation, but unless there's clauses in place enabling you to make those changes or variations, if you do change without permission from the employee, it can cause you quite a lot of problems. They can say it's a breach of contract. So going into consultation is really important. And if you don't get permission, you may decide to enforce a new contract or the employee. We do say this is a last resort, as it could lead to legal action. So it's not just the case of giving them a new contract, they don't accept it, so they've dismissed themselves. There is a set process to go to. So if you're facing this type of situation, do engage with us so we can take you through the right processes to ensure you are compliant. But as a rule of thumb, when making changes to employment contracts, you must always consult or negotiate with employees or their representatives. So for example, if part of a trade union or staff association, explain the reasons for changes, listen to alternative ideas from employees. Having that conversation, being transparent with your employees where you need to make the change gives greater understanding. If you say very little, people always think you're trying to hide something. So we do encourage transparent engagement and communication with your staff when you're looking to make any changes with the reasons why. Maybe they have ideas that they could, make to avoid some of the harsher changes, because employees can come up with some really good ideas you may or may not want to take on board moving forward. But there are different types of employment contract. It's not a one-size-fits-all. So we have full-time contracts, part-time employment contracts, permanent employment contracts, fixed-term contracts, agency staff, freelancers, consultants, contractors, zero-hour contracts, flexible employment contracts, temporary employment contracts, apprentice employment contracts. So the contract needs to fit what the relationship is, what you need from that individual within your business. For fixed term contracts, what's included in this? These last for a certain length of time. It's set in advance. It ends when a specific task is completed, ends when a specific event takes place. So it's very clear the fixed term of the contract, what it's for. But fixed term employees must receive the same treatment as full-time permanent staff. Now, agency workers, if you use agency workers, that's absolutely fine. But if they're working in your business on an assignment for 12 weeks or more, they're entitled to the same treatment as permanent staff with respect to basic pay, etc. Now, all agency workers must be given a key information document which explains their engagement. That needs to include the type of contract the worker is employed under, the identity of the employment business, minimum rate of pay they can expect, how they're to be paid and by whom, any deductions or fees that will be taken, an estimate or an example of what this means for their take-home pay, and details of annual leave entitlement and pay for this leave. So when you are liaising with the agencies, make sure they do give the key information document and also have sight of it for peace of mind. Now, if freelancers, consultants and contractors are concerned, what that actually means is if you are hiring in this area, they are self-employed or part of other companies. They often look after their own tax and national insurance contributions. They might not be entitled to the same rights as workers, such as minimum wage, but you are still responsible for their health and safety. So you need to have a very clear contract relevant to what that relationship is set out, because it needs to be very clear where the obligations start and end. Because if they are freelancers, consultants or contractors, they are not a worker or an employee. But obviously if they decide to challenge this for whatever reason, what the employment tribunal will look at is the overriding working relationship of what's really happening. Is there really a servant master element there? So again, please take advice if you're looking into this area. I get a lot about 0 hours contracts. These are usually for a piece of work or on-call work. So a classic example we give you is for interpreters when they need it. But 0 hours, it means they're on call to work when you need them. You do not have to give them work. They do not have to do work when asked and can't be penalised for that. Also, 0 hours workers are entitled to statutory annual leave and the national minimum wage in the same way as regular workers. And they are entitled to a pay slip at the end of each month, week or month, however you pay them as well, showing what hours they have worked, what annual leave they've accrued, is it in money, is it in hours, and things like that as well. But what is an employee handbook? Now, first of all, just to underline, it's not a legal requirement to have an employee handbook, but to set out the rules of your business, how you want people to behave, what they need to comply with. If you have any other legislation that sits alongside your business that you want to obligate yourself to comply with to make sure you are compliant, then without this, it's really, really difficult to manage people. Some policies are essential and they can be included alongside other relevant policies for your business. But also, an employee handbook is the place your employees can go for information on your business's mission, vision and values. It also sets out the standards and expectations you require of them to work within your business in terms of their conduct and working conditions as well. Because without an employee handbook, if something's not working as well as it could or should, it's really difficult to bring that person back to where you need to be if there's no clear overview of what that should be. Now, a policy outlines standards of good practice for the employee, the employer, or both to follow. Now, unless it says so, a policy does not confer contractual rights. So it is possible to change it without consultation in most circumstances. But obviously any wording in your contract term could depict that. Now, policies can cover a huge range of topics, and they should be kept somewhere that somebody can reasonably access them. A lot of times have it on your intranet or one hard copy in the building anybody can access. You may actually give an employee handbook out. Now, employees need to have read them or at least been told how to access them and directed to read them for them to be applied. So keep a record of evidence that they have. Policies, people say, Jill, policy is the bane of my life. And I do smile. I understand what you're saying, but these are the rules. These make it very easy to manage situations when things are not working as well as they could or should. You know, your dress policy, smoking policy, alcohol policy, people working from home, hybrid working. Do you want them in a t-shirt with a rude slogan on, having a glass of wine and vaping while they're talking on video call to somebody? Probably not. So these rules set out how you want people to be while they're working for you. A right to search policy is important. Harassment, whistleblowing, that's so important. Holidays, you know, how much notice they need to give you, it must be agreed before they can take it, or is it a one size fits all? Because you need a clear holiday policy, because this is how you manage the manpower of your business. Mobile phones cause chaos. Do you want people on the mobile phones? They can do everything on them these days, or do you want them working for you? And if you have people that work alone at times, do you have a lone worker policy? Clear understanding, that's protecting them under a health and safety element as well. So just a few quick examples there, but these are just a few of the policies that help you manage staff to run your business compliantly. It is important to have clear company policies because it does clarify the official stance on numerous issues. I gave the example of somebody working from home just now. It acts as a guide for managers and how they should deal with an issue, because then it's something you can quickly nip in the bud, because the rules are there. And it's a very effective way of having good policies in place for managing and controlling employee behaviour. Now, most employees are brilliant. There are some that decide to, you know, push your buttons, and policy and procedures then really do come in their own to help you. But also it provides justification for you, the employer, to take the action you did in response to your employee's conduct. There are some standard policies that you must have. The data protection policy to comply with UK GDPR, for example. Otherwise, there's no direct legal requirement for you to have many of the HR-related policies, but there are indirect requirements, because if you ever challenge an employment tribunal setting, the employment tribunal wants to see the policies that you have that provided a reference point for you, the employer, to take the action you did against that particular employee or worker. And so they really do offer significant legal protections. And the policies mean that the information is already there and accessible, and they're easy to understand and show what can happen if things aren't working as well as could or should. Employment tribunals really do look at the policies and procedures to help you as an employer to see what you've done and why. So let's have a look at some standard policies and specifics. For example, a disciplinary grievance policy is a must-have, because the contract must include certain details relating to both of these processes, and you also need to put who to complain to and how to appeal. If you have 5 or more employees, including the owners, a health and safety policy is legally required, written down, okay? And also don't forget your risk assessments. But in order for you to meet your obligations under the Equality Act changes in 2010, having a well-defined equal opportunities policy is just so invaluable in setting out standards and you, the employer's commitment to equality. Information relating to sick leave, including sick pay, must be included. Is it, statutory sick pay kicks in on the 4th day? Do you offer contractual pay? If you do, for how long? And finally, you, the employer, must provide information on the pension that you offer. Policies really do help you, the employer, when you're faced with a difficult situation. So bribery, first of all, it's a criminal offence for a commercial organisation to prevent bribery. So if you have really effective procedures to successfully defend should the worst happen, a clear policy is well worth it. Then it enables you to engage quickly, effectively, and to be able to deal with it very, very well. And whistleblowing. If you If you don't have a whistleblowing policy, it could have serious consequences for you, the employer, if a whistleblower is mistreated. Having a policy managers can follow will ensure the relevant obligations are met. So what does whistleblowing mean? It's whistleblowing to the employer. And I see a lot of claims in tribunals, somebody's whistleblown to their employer, they've done nothing, or they've then been targeted, and then they're into tribunal because the employer hasn't met the obligations under whistleblowing. It's not whistleblowing to the authorities, it's whistleblowing to you, the employer, first of all. In holidays, you know, summer is coming, so being caught out by requests. So your holiday policy, carrying over annual leave, do you allow that? Is there a policy dealing with the main issues where holidays are concerned? You know, whether you can agree or disagree, because your right to force holiday on people, you know, how you can do that. Do you have that ability through the policy to give them double the amount of notice for the holiday you want them to take? Do you have the right to cancel it at short notice, and what that means and what the rights are to carry over? And family-friendly leave. To outline the requirements for any kind of family-friendly leave is recommended. It provides clarity. And if you, the employer, intend to offer enhanced terms, what they are, and it's vital the terms are to be set out clearly to help you manage when you have these issues and requests coming in. What about other recommended policies? Because employers really do benefit from having them. It depends on the nature and the industry of the business, but good ones to consider still the COVID testing policy, the social media policy, protecting your business as well, vaccine policy for COVID, an IT and communications policy. You think of all the information held on business laptops and protecting that as well. And sickness policies, such as the procedure to be applied for long-term sickness and absence reporting. We provide many policy templates with the Kroner service, and these will be then really written to how you need them on this bespoke service. So, you know, what the social media policy terms and conditions of use are, your sickness absence policies and procedures, you know, is it statutory sick pay, how to return to work? What about disability? Are there reasonable adjustments that need to be made if they reach a definition of that? Access to medical reports, long-term sickness. So enables you to deal with things in a timely manner, in a robust way that's clearly understood from both parties. A policy isn't an exhaustive list of scenarios or behaviours. You know, for example, the disciplinary policy shouldn't be a definitive list of behaviours that it will be applied to. A policy are not forms to be signed. Now, an opt-out agreement for the working time regulation should be signed and returned by the employee. And also the policy will give information related to the opt-out. So that's under the working time regulations, that's clearly defined. The contract of employment, they can contain its terms if specifically identified as such. So again, this really depends on the nature of your business and the risk of your business as well, what needs to be in there. And we really do advise you to regularly update policies, because if you don't, outdated policies really can put your business at risk. So when was the last time you updated your policies and procedures? Do they really reflect what you need from your staff in the business arena and any other legislation? You know, if you think how much things have changed the way we work in the last 2.5 years, then they need to be reflective. A big change was the introduction of the Good Work Plan. It has significant impacts on employment rights, and we're seeing the claims come through now. Because old policies may fail to comply with the new laws and regulations. So keeping, you know, marking your calendar on changes that are going to come into place. So if you pay the national minimum wage, that changes on the 1st of April each year of the payments that need to be made. But you need to keep tight and accurate records when people go into those key age groups that it increases. And also the yearly gender pay gap reporting deadline. So if that applies to you, make sure that's diarised so you don't miss it. But if a policy does need changing, is it a contractual or non-contractual status? Because the status of the policy will affect how easy it is to change. If it's not explicitly clear from the policy what status it has, how it's used will have to be looked at closely to try and establish this. Now, non-contractual changes, you can simply implement the changes by informing those affected and updating the relevant documents that they can then engage with. But if it is contractual, then you really must go into engaging with your staff on this. It means things like bonus payments, and we're seeing this a lot now, where the pandemic has really affected business and bonus payments. So if you feel that they can't be paid and they're contractual, you need to consult on them before they change. Because if the employee doesn't consent to the change, then a process needs to be followed to make the changes can be disruptive. And again, if you explain to people why those changes can be made, it can avoid any employment tribunal claims moving forward. There is a risk if the employer gets it wrong. So any time as you, the employer, make a change, you can run the risk of an employee opposing it. This can lead to complaints, grievances, and impact on productivity and performance. So consulting and informing on why you want to make the changes happening is really important and in some cases essential. If the policy is contractual, changing it without consent would be a breach of contract. And the employee could bring a claim for any financial loss resulting of that, because it could also result in an underpayment of wages. But if you do make the change unilaterally, if the employee is so aggrieved at what you've done, they can leave and claim constructive dismissal. Or they could write to you saying they're working under protest, so then you have to go into engagement. So any changes, please do reach out to us for advice if you feel that's important to you. We see such a lot of breach of contract claims, constructive dismissal claims, because an employer made the changes, they thought they were doing the right thing, and actually end up, it can be a very costly exercise. I know it's been quite a whistle-stop tour. Contracts, policy, procedures, and my laptop is going absolutely crazy. I do apologise about that. But I'd like to thank you for joining me on this webinar. And as I mentioned to you, you have free advice through your REC membership. So your number is 01455 858 126. When you use this number, could we please ask you to quote the code 86412 so we can identify you as IIRSM, and you have the free advice through the membership. If you do have issues in your business now, reach out to us. Let's talk to us, because getting it right first time is key for you. For any changes you want to make in your business, totally understand, we are reacting to all things that are happening around us as quickly as we can, but it is at all times protecting your business and protecting your staff as well. They need to work together. So I'd like to thank you for joining me on this webinar. And if you do have any questions, then please don't hesitate now to engage with me. Thank you for your time.
Thank you, Jill. That was really, really informative and interesting session. We do have a few questions that I'll go through now, and for everybody else, please feel free to continue to write those questions in the box on the right. So the first question we have is, when do I need to issue a contract?
The latest you need to issue a contract the very first day they join you, but I do recommend to get those signed before they actually come into your business, so it's very clear what the relationship is.
Thank you. And somebody says here, if I want to make a contract to all my employees' contracts of employment, do they all need to consent to the change before I make it?
If you want to make a contractual change, yes, you do. And you need to have a really good audit trail in place to show how you've engaged with your staff on that and the agreement as well, to prevent any breach of contract claims.
I imagine that can be quite a lengthy process for a large organisation.
It doesn't have to be, it depends on the changes you want to make. But, to start off, having the conversation, it really is a benchmark for how people are going to react as well. And so it can be a really good guideline to what processes you may need to engage in. And we help businesses with this all the time.
And is it a legal requirement to have a health and safety policy?
If you have 5 people or more in your business, including yourself, yes. But you really need to have at least risk assessments, even if you're a very small business, because if anything happens, the first thing I want to see is how you risk assess situations in your business and people working within them.
Perfect, thank you. Well, we haven't had any more questions come through, so I think we'll leave it there. Thank you so much again for sharing your knowledge with us, Jill. And thank you to everybody else.
Sorry, my the slides went a bit haywire at the end.
Oh, that's okay, at least it was at the end. Thanks everyone else for joining us. Just to remind you, the recording, the session has been recorded, so a recording will be up on the YouTube channel either later today or tomorrow, so you'll be able to catch up on any things that you've missed in your own time. And that's it from us, so I will end the webinar here. Thank you everyone once again. Take care.
Thank you for your time.
Cheers, bye.